Well, good afternoon, everybody. Bill O'Leary here from Legacy Planning Law Group, an attorney here, and this is what we call our Thirsty Thursday series, um, where each week I'm going to be talking about a different topic that relates to sort of what we do. Maybe one week it's going to be talking about wills and trusts and powers of attorney, what we call estate planning. Maybe another week it'll be talking about issues more focused on our what we call elder law. Maybe it'll be talking about things that have to be dealt with, topics that come up after somebody's passed away, administering their estate or their trust. And so again, I'm going to sort of be rotating topics around each week at this time. Our Thirsty Thursday series, we call it Thirsty Thursday because if you're thirsting for knowledge, you come to the right place. And before I get started, let me go ahead and sort of get this out of the way. You might be looking at my forehead. Um, let's just say that I got into a fight with a car door and I lost the fight. So we'll just leave it at that. All right, so what's today's topic? It's how to plan for a fragile beneficiary. A fragile beneficiary. So what does that mean? Well, maybe you've been thinking about putting your estate plan in place, maybe updating a plan that's been around for a while, that was done a long time, but you're not exactly sure what it's going to look like. You know who you love, you know what you own, but you're not exactly sure or not completely confident that everybody that you have in mind is capable of taking on an inheritance. Maybe some are more capable than others. Now, does the fact that you have some loved ones that you don't think are quite able to handle it, does that mean that you've got to cut them out? Does that disqualify them? And the answer is no, absolutely not. They're your loved one for a reason. They just require a little extra care. This is fairly common in many people's estate planning, and this may describe you. So, this is sort of a group of people I like to call fragile beneficiaries. Fragile beneficiaries. Again, they often need a little bit more care, a little bit more thoughtfulness in the planning. So, who are these fragile beneficiaries? Well, there are several different types that we see fairly often. So, the first is kids, minor children, children who are minors under the legal age of 18. Well, why are they fragile? Well, for one, they're kids, but the legal reason is they're legally they can't receive an inheritance. They're not allowed to. The law prevents them from doing that. So, how do we deal with that fragile beneficiary? Well, we very often will establish a trust for them so that if they happen to, come into an inheritance when they're a minor, that it's going to be set up in sort of a protected way that's going to be there to help the kids, and we don't have to involve the court system. And so that's setting up a trust for them where the money can be used in the trust for their benefit while they're minors. A lot of times that trust will extend beyond age 18, to age 25 or 30. That's very common that parents want to do that. And we're able to name a trustee, somebody who's going to be in control of that or manage that for the kids. So that's minor children is one very common type of fragile beneficiary. Another type is a beneficiary that has a disability or maybe a special need, what we call special needs individuals. And the problem is the reason why they're fragile is because in many instances they are getting financial help from the government. They're getting what are called public benefits, things like SSI, supplemental security income from the government. They may also be getting their health care paid for by Medicaid. Well, these programs have strict eligibility requirements, and basically, the disabled person can't have too many assets. Well, what would happen if the special needs loved one, the disabled loved one, came into inheritance? Boom, they're knocked off the public rolls. They're no longer eligible for SSI or Medicaid potentially. And so that is another type of fragile beneficiary. We don't want that to happen. We want them to continue to be able to get that public benefit. So this kind of planning often involves, similar to a minor children, setting up a trust for the disabled loved one. This is a special kind of trust, what we often call a special needs trust. And the idea is that the money that's going to go into this trust at your death is going to be there to take care of your disabled loved one, but not in a way that's going to knock them off the public road, disqualify them from the public benefits. Okay, so beneficiaries that have a disability or special need is another type of fragile beneficiary. How about beneficiaries that are easily influenced? Easily influenced. Okay. Well, what might that be? Well, let's say a child, even in an adult child, if you think that the child is susceptible to being influenced by others, to where their inheritance might sort of, get, if you will, then you can put in protections. Again, that's often by setting up a trust. A trust is a commonly used way to protect an inheritance for a fragile beneficiary. So therefore, it could be used for a minor or for an adult child. How about a spouse? How about a spouse? And I've seen situations where one spouse is concerned about the other spouse's ability to say no, to say no to others, and it runs the spectrum. Sometimes the other spouse is a young, and sometimes they're older. I had a case for a couple in their late 20s, and the husband was very concerned that if he were to pass away prematurely, that his wife, about the same age, she's easily influenced, particularly by certain members of her family, and he wanted to make sure that the family inheritance was protected. We also see it with older spouses. So let's say a couple in their 70s or 80s, and the concern there is, oh my gosh, if one spouse passes away, the surviving spouse, once he or she starts to decline in health or maybe develop cognitive issues, might be easily influenced. By who? Well, maybe a caregiver. So there are ways to protect that inheritance. So spouses can be thought of in certain situations as a fragile beneficiary, where there's a desire to protect that inheritance for them. How about the next group? Beneficiaries who need an incentive. Okay, some beneficiaries, some heirs just need a little bit more motivation than others. Sometimes using a carrot and stick approach can help to encourage certain behaviors and discourage other behaviors. So again, we can use a trust for this purpose. We sometimes give it the name an incentive trust, okay, where the money in the trust can be made available, can be distributed to the beneficiary if certain milestones or performance measurements are met. So it can, for example, encourage certain behaviors. Maybe it can say, hey, if you graduated from a credited four-year college, you're going to have X amount of money distributed from the trust. If you first job, money can be distributed from the trust. So again, you can have the incentive trust encourage certain behavior. You can also have it discourage certain behavior. For example, addiction, drug dependency, whatnot. And so it can say, well, money will be distributed, but if you become addicted to drugs or alcohol, let's say, as determined by the trustee, which would be somebody else, then the distributions can be stopped until you complete a treatment program. Case in point. Okay. So again, fragile beneficiary, those loved ones who need some incentives to either do the right thing or not do the wrong thing. And then how about protecting a beneficiary's inheritance, even if they are the quintessential responsible adult child, protecting the inheritance, okay? I don't know what, protecting it from a possible divorce that your child may go through, or what about your child getting into a car accident and getting sued? Well, I'm sure you would not want to see the family treasure leave the family bloodline and go to the divorce or the lawsuit. So, although probably not quite a fragile beneficiary, that is an example where the inheritance might be considered fragile or at risk, and there are ways to protect that. Again, very often using a trust. So I think you're sort of seeing a trend here, using a trust. So those are some examples of fragile beneficiaries. Look, if you'd like to know more about how you might about planning for a fragile beneficiary. And if you'd like to know more about how we can help, I would strongly encourage you, hey, schedule a 15-minute phone call. It's free to you. You can schedule it on our Facebook page or the Book Now button. You can give us a call at 904-880-5554 or just Google us, Legacy Planning Law Group. And again, the purpose for this call is really to see if we both would be comfortable working with each other, and also for us to get a better understanding of your situation so we can tell you if we can help you. Okay? So with that said, hey, if you've liked this video and enjoyed it, hey, if you wouldn't mind liking it on the Facebook page, and better yet, if you wouldn't mind sharing it with your friends, we would really love to sort of get the word out. So again, I hope you've enjoyed this talk on fragile beneficiary. I plan on talking next Thursday again about this same time. Different topic, but same time for the next at least couple of months. We're going to be doing it here at or around 12 o'clock noon. So again, if you're thirsting for knowledge, you've come to the right place. So Bill O'Leary signing off for now, and again, on behalf of everybody here at Team Legacy, I want you to go make it a great day.